This is the October 13th, 2016 Police Oversight Board. I'm calling this meeting to order. Let's have the Pledge of Allegiance, which will be led by Leonard Waits. Please stand if you're able.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Let's move to the approval of the agenda. We've been asked to be flexible about item 6B. There's an attorney for an officer who would like to come and speak with us briefly about that. He is in court, and so we are going to be flexible around that. We'll bump it to after the consent agenda, and if we're still unable to have him be here, we'll just bump it down until he appears. Public comments. Okay. Sean Willoughby, is this you?
Yes, ma'am.
Great. Mr. Willoughby is the current president of the Police Officers Union here in Albuquerque.
Yes, ma'am. Thank you very much for the opportunity to stand before you and speak this evening. I know I have 2 minutes, so I'll keep my comments quick.
Great.
Thank you for your time. I have three? Oh, great.
Yeah.
I'm used to city council, so I talk fast. I'd like to start off by saying, me and Ed Harness, I think we have a good professional working relationship. I respect him and his skills within the job that he's performing. I respect the CPOA and I respect this board. I respect civilian oversight and the ideology that it's a necessary function of policing in the 21st century. I'm talking to you tonight because I want you to be a little more involved, and I want you to look with your own eyes at CPC 88. I think you have the power and authority. This board can look and view CPC 88. You can look at the case that was done. You can look at the documentation. You can read the garritarized statements. I want you to really give a hard look at that case. There were a lot of allegations that came out of that case. I watched videos, I watched commentary both back and forth about the use of NCIC as it relates to this case and the derogatory comments towards police officers and our ability to police ourselves. I mean, if internal affairs and bias, I haven't got the memo because I'm in there representing officers every single day. I think a lot of work was put into that case, and I think it's imperative for this board to know that even though it may be different in a different state or somewhere else, in the state of New Mexico, you need absolutely nothing, no reasonable suspicion, no reason at all to run a license plate. The Supreme Court in this state, the Court of Appeals, has already ruled in case law that I can dictate to you that because it's out in the open, there is no expectation to run a license plate. In fact, the city of Albuquerque employs license plate readers, where we drive down our city streets and we run hundreds, if not thousands, of license plate at random. When police officers go to any stoplight, they're running the license plate in front of them. They're running the license plate beside them. They don't need a suspicious circumstance to do so, nor does the driver need to be aware. There's absolutely no law. It's not illegal and it's not a breach of NCIC. NCIC and the Motor Vehicle Division are two separate entities. From MVD, you can purchase the ability to run license plate. Our media in this city has the ability to run your license plate because there's no expectation of privacy in your license plate. The owner doesn't necessarily know that it's been ran, and you don't have any identifying information to determine that the person that you're seeing or witnessing inside the vehicle is the actual owner of the vehicle. It's basically an investigative tool. The only time it carries over into NCIC is when it says the vehicle is stolen, which is verified through NCIC. This is a missing person. Maybe this is an offender vehicle of a homicide. It does branch over into NCIC. But in this particular case, number 88, the police officer never actually ran somebody through NCIC for a warrants check. They didn't run him for a social security number. They didn't run him to identify him. They ran a motor vehicle check through his license plate. A lot of talk was, I guess they can run license plate for whatever. And the truth of the matter is they can. And I want to dictate the case law in the Court of Appeals so that you can take careful consideration of reviewing this case for yourself before you're brought down any roads of action.
I have a question. So my question doesn't have to do with running license plates. It has to do with police officers' ability to access NCIC. I'm not talking about this case in particular. I'm asking, doesn't there need to be a lawful purpose for someone to run an NCIC check on somebody without, in order to do that? Isn't that the case?
In order for me to go to the National Crime Information Center, which I click to the radio, I go to NCIC, and I'm running a warrants check or an ID check. Yes, you have to have a law enforcement purpose, but I want the clear distinction between running a license plate and running somebody through NCIC. They are two totally different
Okay, I
things.
heard you. And then the second piece I have is if someone is suspected of running an NCIC search without a lawful purpose, isn't there somebody in Santa Fe with DPS, that Department of Public Safety, that is supposed to check on that? If that was done illegally without lawful purpose?
If there was something that was done illegally and it was notified, if it was blatantly illegal and the powers that be were notified, there is an agency to verify and check that. And to add to your question, there's also a mechanism within NCIC to verify that it actually happened. What I'm talking about, so to answer your question is yes, there is an agency to do that. But what I'm talking about is to say that somebody, if you read the case and you have access to the case in totality, you will see that nobody actually accessed the NCIC database to run a particular individual. What happened was a license plate was ran. That is completely justified. I don't need a reason to run your license plate as a law enforcement officer, and that's confirmed through Court of Appeals case law in this state. It's also confirmed through most circuits of the United States because there's no expectation of privacy in your license plate. It's in plain view and it's open to everybody.
Okay, thank you.
And if you would like the case law, I'll have it. I don't want to take up too much of your time.
Okay, thank you, Mr. Rolby. Is there any other public comment? Okay. I think we have everybody present for CPC 8816. We'd like to open this up, Mr. Grover. Mr. Thomas Grover is representing Sergeant A in this case, and he's asked to provide a brief statement.
Good evening, Chairperson Moore and members of the board. Thank you for indulging my request to address the board regarding CPC 88-16. I speak not only as an attorney representing a highly respected sergeant of the Albuquerque Police Department, but also as a former sergeant of the department. I was brought into this matter at the request of my client, Mr. Anaya, who is here, and let me just state for the record, he is here at his individual capacity, not as a representative of the police department, and he's not speaking for the department, he's speaking for himself. And I just want to preface his statement with a few comments. The CPOA is a organization that is growing and evolving, and it's in a dynamic and turbulent environment. It's in an environment where its boundaries have yet really been defined, and it certainly hasn't established deep roots into its operations and conduct. As such a young entity, its credibility and the level of integrity that this agency and its director must be without reproach. Under the Genesis ordinance for the Police Oversight Agency, the purpose of the agency is simply to foster mutual trust and cooperation between police and civilians. It's also to provide civilians and police officers a fair and impartial system for the investigations and determinations on civilian police complaints. And I don't think there's anything that anyone else would want other than fair and objective and independent investigation and analysis and review of any matter that comes before the board. Because we know that the second somebody puts their thumb on the scale, tries to conceal or omit information, we don't get objective determinations. We don't get fair and impartial findings. We get skewed determinations and we get agenda. And frankly, agenda is what has landed this department in its current situation, where it's under the scrutiny of federal agency, the citizen, the general population of the city, former officers like myself who went off to become attorneys. Now, when Mr. Anaya approached me regarding this matter, the assumption was this is a run-of-the-mill administrative investigation regarding a citizen police complaint. And frankly, right off the starting line, we ran into issues in terms of what was being investigated. what were the issues. Because Mr. Anaya is not just a mere police officer with the department, he's also an active witness in a significant criminal investigation involving department personnel and inappropriate financial action for timesheets. And the timing of this investigation was all too convenient as it relates to that ongoing investigation. So as someone who wants to see this department thrive and come back to the place where it was, where it had impeccable reputation and was a place where people could rely on and feel good and knew that calling the police was a good thing. They weren't worried about what might happen. And the department could operate in a manner as opposed to being concerned about who's watching them and what conduct might be perceived as improper. I felt like this particular case needed unquestionable objectivity and examination, and that brought me into it. And I've been functioning as Mr. Anaya's attorney pro bono. I have spent close to 100 hours invested in making sure that Mr. Anaya is properly represented in this case. And he's here today to simply address any of the concerns that have been raised in this matter. And there are substantial concerns and representations that have been made by the director in his representations to this, the subcommittee concerning this case, his own actions, and there's no better person to address these concerns that have been raised than Mr. Anaya himself. So with that, Mr. Anaya is going to make a brief statement and we'll stand for whatever questions you all might have. Thank you.
Thank you. Good evening. Again, my name is Adam Anaya. Thank you for giving me the opportunity to come speak before you. So first of all, before I start, you all know my occupation. I have no idea what your occupation is, but I want you to think about this as I talk about it. How many of you, when you go out to work every day, have to have a bulletproof vest? How many of you have a gun that you take to work regularly with you? How many of you have kissed your loved ones goodbye maybe for the last time? How many of you have been targeted or received threats because of the uniform you wear or the job that you do? I just want you to think about that. So as I'm discussing this case, it's easy to judge people from the outside. It's a little more difficult once you're in those individual shoes. Okay. With the issues that are police officers that are facing, not only in this city but nationally, many police officers have a very difficult job. It's in the news every day. There's an officer killed here, an officer killed there. I have a webpage that I was looking at, and a few months ago in Maryland, 2 officers were killed while they were eating lunch because they were wearing a uniform. Somebody walked up to them and said, "I'm going to kill those individuals because they represent the police department." So as I address this board today, I want to talk about my case and what I'm involved in, and how I feel that it's been misrepresented by Mr. Harness and his. I'm not sure if he has a personal vendetta or some kind of agenda against myself. It seems like there is one, based off of the circumstances with the New Mexico State police investigation and how individuals that are tied into my case, Mr. Tyler, and individuals that he's related to, have a vested interest in this New Mexico State police investigation, which I'm not going to discuss because it's an ongoing investigation through the DA's office and New Mexico State Police. But I feel that Mr. Tyler is representing something that is asked for by the citizens. The citizens want a change in the police department, and we all want a change in the police department. It's not a perfect entity, it's not a perfect organization. Neither is anything that you guys do. There's always going to be sour apples somewhere. But the citizens have asked for this, and they're getting what they want. They want citizen police oversight. But when you have an individual that does not hold or pertain his authority and his job the way that he needs to do, it causes issues. It causes mistrust. It causes concerns. All I can say is that individuals that are placed in these particular situations with authority and power, they should take that seriously. And what I mean by that is, if you're gonna go out and do an investigation, which I believe he's an ex-police officer, and he should know that he needs to go through the steps, the proper steps. Maybe look up some case law. Maybe actually do a good investigation. Maybe when he comes to present the information to you, he gives you the information that is just, correct, and justified. Not tweak it and leave out important information based on his agenda, wanting to make an example out of somebody. You know, I don't want to say he lied, but I'm not going to say he didn't. The things that he brought up to this board that I watched, I was flabbergasted by it. I said, what investigation is he talking about? Because that has nothing to do with the one I'm involved with. You know, I know Sean talked to you guys about the running of the license plate. Well, here's from New Mexico Law Enforcement Academy, what they teach in the Fourth Amendment search and seizure lesson plans. Okay, and this is state law. This is State versus Herrera, 2009. And it simply states in here, the Court of Appeals held this wasn't a search because a person doesn't have expectation of privacy in a license plate. Okay, the things that took place that day was an individual walked into a restaurant that I was eating at. The individual walked up and placed himself in a close distance that normal citizens don't do. Okay, as a police officer, we're trained to observe these cues, these visual cues. You know, as soon as he walked into the restaurant, it caught my eye. The restaurant is empty. He sits directly next to us, within 4 feet from us, not up against the wall, all the way to the side, right next to us. The individual holds up his phone. He's facing the direction, is holding the phone up and recording us the entire time. Every time I looked at that individual to make eye contact with him, he turned his eyes. Visual cues. I have no idea who this individual is, what his motives are. But I've seen this and I've received bulletins throughout my career. Watch out for individuals, this, and this, that people want to hurt you. Okay? That's fine, he can record what he wants to record. It's a free country. But when the cues start coming, safety starts being a concern, not just for myself, but for the other individuals that are in that restaurant. You know, as the individual finishes his meal, he stays there, not on the phone, not having a conversation with anybody, holding the phone in my direction, filming me. So he decides to leave, but he forgets his tray and he goes up to the front, turns around, and then comes back, grabs his tray, and starts taking pictures of us. For what? I don't know. Is this going to be a murder and he's going to post it on the internet? I have no idea. There's much concern though. Much concern. There's citizens there. Could have been you guys. Any one of you. So, I do what I'm trained to do. I didn't confront him, I didn't talk to him, I didn't do anything to him. I obtained his license plate information. And I ran it. I didn't obtain his personal information. I didn't use it for my own just cause. I didn't do any of that. I obtained his license plate information. That's all I did. I had every right to do it. And would I do it again? You bet I would. So I got that information, and another flag came about. Wow, look at this name. This is awfully strange. Why is this individual in this restaurant when his spouse is 1 block away? That's very strange. Given the circumstances of the Mexico State Police investigation, I start putting things together because that's what we do. I'll let you guys figure that part out. I'm not going to discuss it. But I didn't use his information, I didn't run his information to NCIC, I didn't do anything with his information. The only thing I was gonna do, until I found out who the individual was married to, was provide it to our intelligence unit and ask them, have you had anything with this individual? These are the circumstances that took place. Maybe we need to put a bulletin out on this individual. Maybe you guys are actually working the case. He was acting not normal. Yes, ma'am.
The difference between what we were told and what you're saying now really hinges on one piece. And that piece is that you ran NCIC on this person.
I know that, ma'am. I
Is
saw
that,
the video.
and you're saying, if I'm hearing you correctly, you're saying you did not do that, that is not true.
That is exactly correct. And the answer, I don't remember who asked the question, but I remember the question being asked directly. Did this
I asked that question.
officer run him through? And
Yes,
his
we have
question-
confirmation that
Yes.
I'm the one that asked that question in
Okay.
the committee.
And you were told, yes, he did run him.
And you're
through.
telling me now that that is not correct? Is that what you're telling me? I want to
Yes.
make sure I understand it.
Yes.
Okay, fine, then I would propose that the case review committee take another look at this, because
What? Okay, go ahead.
that we not deal with it here in this venue. That's my suggestion.
Let me ask another question, if you don't mind. I know that the information that we receive is information that was done through the investigation, correct?
I would say no,
Why would you say no?
because you were lied to.
Okay.
All right, and
My,
let's be clear before we go too far, this is not a hearing, this is not an appeal.
Right.
This is the APD employee and his attorney wanting to make a statement.
okay.
And so I'm not gonna sit here and hold a hearing, that's what's not happening.
No.
We're gonna allow Mr. Harness to run through what he wants to tell us on this case. In 7 words or less, Mr. Grover, what would you like out of this? What would you like this board to do with this?
Well, I'm not done now.
Yeah.
Okay, keep it short then, okay?
I will, I promise. So, yes, I remember exactly hearing those words come out of your mouth. And I remember exactly what the words came out of Mr. Harness' mouth, and I said, wow, unbelievable. Unbelievable. I do also remember seeing an agenda, I think, for this meeting about concerns that the board had about individuals coming into here and recording the meetings and then placing something on Facebook. Is that, I could have sworn I read that. If I didn't, then, okay.
This is a public meeting, anyone can record any portion of
Right,
it.
I know.
The whole thing's
So I was
recorded.
kind of flabbergasted by that concern. So my last point is, the integrity of this board is being put in is being jeopardized by an individual who has a personal vendetta or a motive. Now what that is, I don't know, and I don't really care. But it's not fair to you, it's not fair to me, it's not fair to the citizens that the individual is not taking his job and his responsibilities seriously. You know, police officers are held to a very high standard. And when we do something wrong, well, you bet your butt it's going to be all over the news. But we have individuals that don't take their job seriously and don't want to provide you the information that you are requesting in an honest and trustworthy manner, then I have issues with that. Lastly, I want to just all in on this. So how many of you in your work, this kind of goes back to my first statement, have received emails, text messages, phone calls, and saying that somebody wants to look out for this particular individual, that they just received a call from 911 saying individuals are going out hunting police officers today, based on what you're wearing. Individuals are going to hurt you, find your information, post it on the internet with your family's information and your address, and go to your house and kill you and your family.
Are you asking who's had that happen?
I'm just saying
I
that.
have, yeah.
Yeah.
Members of this board
It's not a
have
good
received
feeling,
death
is it?
threats, so you probably don't really want to ask this question.
I'm asking, it's not a good feeling, is it?
No, it's not.
So then when we are confronted with an individual who's acting suspiciously and maybe has mental health disabilities, us as officers, we're trained for that. And that's what I did. I acted on it, and I obtained the information I needed. I didn't need to go any further. Once I realized who I was dealing with, I don't need to run his personal information. The information I obtained was through a license plate where there's no expectation of privacy. It was not ran through NCIC. It was ran through the Mexico Motor Vehicles Department. Thank you for your time.
Thank you, sir.
Chairman Moore, members of the board, as an attorney that's representing current and former officers that are suing the department, suing the prior chief, suing the current chief, and who have even sued the police union, the mere fact that I am in a total agreement with this chief and with the police union speaks volumes. Okay? The chief's recommendation in this matter was that there be no disciplinary action, that regarding conduct relating to SOP 1-4-38A, that the finding be not sustained in terms of any violation of that SOP, and regarding the allegation of violation of SOP 1-37-3A3, that Mr. Anaya be exonerated, and we would request that the board adopt the chief's recommendation regarding this matter and consider it closed.
Okay.
We have more work to do about this.
Mr. Hines.
Chair Moore, fellow board members, good evening. Well, a couple of things. I'll point out that before this meeting, you had no idea who the subject of the investigation was. Beyond that, there's a fundamental misunderstanding of what happens with oversight in Albuquerque, and understanding that the chief's recommendations are the final say, that this board only recommends to the chief, and the chief's findings are final. And in this case, the chief has decided for not sustained and exonerated, as pointed out by Attorney Grover. So, in context, I will share with you the department's non-concurrence portions of the findings.
Excuse me, the department meaning
APD.
ABQs.
We are here on the officer being not sustained and exonerated in this case. My problems with the case was that it was not handled properly in accordance with the settlement agreement, paragraph 188. And you have before you the packet of materials that outlines the department's position. And I'll simply go to Commander Sullivan's review of this case. Commander Sullivan is the commander of the Northwest Command, and the chief concurred with the commander's findings of exonerated.
And just to be clear, this investigation was not conducted by your office, Mr. Harness. It was initially with your office, and then it went to Internal Affairs, and Internal Affairs completed the investigation, is that correct?
That is correct. The only phase of this investigation that was conducted by our agency was the interview of the complainant. Once that complainant was interviewed, and we thought that there may be criminality, not that we said there is criminality, that there may be criminality, we turned the investigation over to Internal Affairs and had nothing else to do with the investigation.
But the thought that you had about the possible criminality was based on whether or not NCIC was run.
That's correct. And whether or not there was a lawful predicate for the officer to gain that information, and whether or not that officer who was at lunch with another officer and a civilian, and whether or not that information may have been shared with that civilian, along with whether or not the officer had the right to gather that information. That's the only question, and the question wasn't for us to answer. The question is for the New Mexico Department of Public Safety to answer, not us, and not the Albuquerque Police Department. I never made a judgment I only said, this is the possibility, that's why I went over to internal affairs.
Because the way I read this non-concurrence, the chief is not concurring with the sergeant from internal affairs. Is that correct? Did you ever make findings on this?
We never made any findings in this case.
Okay, continue. Just want to make sure I understand this.
Commander Sullivan says, after review of this case, I concur with Sergeant Cimbala's findings of exonerated. The facts of this case are not in dispute. Sergeant A fully admits he did run the license plate through the department's MVD/NCIC system. However, upon interview of Sergeant A and his two witnesses provided significant testimony to support his decision. Sergeant A is able to articulate specific behaviors, highly unique scene choice, apparent use of cell phone to record, and what appears to be a picture taken, displayed by the complainant during this incident. Sergeant A states the circumstances surrounding behavior caused him to feel the complainant was suspicious, and he related these feelings to recent attacks on law enforcement nationwide. The totality of the circumstances caused him to feel the need to attempt to identify the complainant. Sergeant A also clarifies his intent upon gaining this information was to hand it off to Strategic Criminal Intelligence Unit for possible follow-up. This action would be both correct and appropriate. Upon review of the only contrary testimony to Sergeant A, and this is Commander Sullivan, I once again find the investigation to be incomplete. Complainant states he did send Sergeant A and R and the civilian Mr. Lopez knew he overheard their conversation. However, Investigator O'Neill fails to inquire or clarify if the complainant felt his actions and behavior caused them to notice. When Ms. O'Neill asks if the complainant recorded the group, he emphatically states he did not. Ms. O'Neill then attaches the question of or take pictures or anything to her previous question. Complainant does not provide a direct answer to the pictures question. However, Ms. O'Neill either fails to notice or chooses not to press for any answer. This question is very relevant to this investigation as the wife of the complainant later testifies there was a picture taken. Therefore, I must conclude a picture was taken at some point, thus validating the statements and concerns expressed by Sergeant A. Based upon the testimony provided by Sergeant A, Sergeant R, and Mr. Lopez, all of whom felt the complainant was acting suspiciously enough to warrant identification, and the lack of compelling testimony to the contrary, I find Sergeant A did not violate SOP in this incident and recommended violation is exonerated. Regarding the memo dated September 8th of 2016, included in this file was a memo from Executive Director Harness of the CPOA to Chief Eaton. In his memo, Executive Director Harness states that Sergeant Cimbala's investigation is in violation of the court-approved settlement agreement with the Department of Justice. He specifically cites paragraph 188 as being violated. Mr. Harness states he feels this case should be submitted to the Federal Bureau of Investigation for a violation of U.S. Title 18 as a part of my review, I examined his position. During Sergeant Cimbala's investigation, he documents the steps he took to determine if criminal charges would be warranted on Sergeant A. Sergeant Cimbala states he spoke with Criminal Chief Assistant United States Attorney for New Mexico, Mr. Burkhead. Included in the case file are email correspondence between them. In these emails, Mr. Burkhead indicates, quote, "It is exceedingly unlikely that the District of New Mexico would move forward with a federal prosecution." Mr. Burkhead further clarifies that charges would only be warranted if information gained from the NCIC records were used for the purposes of financial gain, perpetuate a fraud, or further a larger conspiracy to commit a federal offense. Sergeant Cimbala also states he spoke with multiple State of New Mexico Assistant District Attorneys, all of whom felt criminal charges would not be warranted. As an additional level of investigation, I personally looked up U.S. Title 18 offense mentioned by Mr. Harness. Upon my independent review, I concur with Mr. Burkhead without some overt act or intent to use the information gained in some criminal fashion, there is no violation of federal law. I further investigated by checking New Mexico state statutes for any possible violation. I reviewed New Mexico state statutes 30 through 45, computer crimes. Once again, I found that unless the information was gained with an intent to defraud, embezzle, or cause damage to computer systems, there would be no violation of the law. I find absolutely no testimony indicating in any fashion that Sergeant A did or intended to use the complainant's information for anything listed above. My final step in examination of Executive Director Harness's memo was to contact APD Communications Director Erica Wilson. Ms. Wilson stated, in New Mexico, when it is suspected law enforcement agents have inappropriately used the NCIC database, it must be reported. She also stated that the New Mexico Department of Public Safety would be responsible for any investigations into misuse of the system based upon their regulations. Based upon her statement, I, Sergeant Sullivan, request that she initiate a request to the DPS NCIC Security Office to investigate Sergeant A's use of the NCIC in this case. I review, this is Commander Sullivan, I review of Executive Director Harness's statement that this investigation violates the CASA, specifically paragraph 188. I do not concur with Mr. Harness. I find that the Chief, via his designee, Sergeant Zimbala, did consult with the relevant prosecuting agency and federal law enforcement regarding the initiation of a criminal investigation. Based on all the facts available to me at the time of this review, ICAPD has complied fully with both the spirit and intent of paragraph 188. In summary, I do not find that the use of NCIC by Sergeant A in this case rises to the level of criminal misconduct. I base this decision on the conversation Sergeant Zimbala had with federal and local prosecutors and my own investigation into relevant laws. I have close to 18 years of law enforcement experience, over 10 years which has been in criminal investigations. I have worked in countless joint investigations with local, state, federal law enforcement partners. I have also investigated officers and APD employees for misconduct in criminal cases. I have hundreds of hours of training and practical experience in interrogation and interviews, therefore establishing my basis for findings in the aforementioned case. Commander Sullivan signed off on this on the 13th of, Commander Sullivan signed off on this finding on the 13th of September. Chief Eden signed off on this finding on the 15th of September. On the 20th of September, Erica Wilson, the commander of the Communications Division, the manager of the Communications Division, sent the following letter to the Department of Public Safety. Dear Chief Chacon, on May 5th, 2016, the Albuquerque Police Department Sergeant A was on a lunch break at a restaurant. On this date, Sergeant A was attending a training at the APD Academy. On May 10th, 2016, the Civilian Police Oversight Agency received a complaint from a citizen regarding Sergeant A, which alleged possible CJIS misuse because the citizen believed his plate, New Mexico license plate number, was run on May 5th by Sergeant A, and the citizen additionally alleged that Sergeant A was speaking in an unprofessional manner about Albuquerque Police Department, which could be overheard by others. Sergeant A noticed the citizen watching him and observed him take a photo with the department-issued vehicle, which caused concern, and Sergeant A catalog shows he did run the plate. I am currently not privy to all of the details regarding the situation, but I have provided you with the basic details. Her letter goes on. The investigation was passed from the CPOA to the APD Internal Affairs Division for investigation, as the CPOA believed there would be a criminal investigation based upon allegations of the CJIS misuse. Internal Affairs was not aware of our requirements to notify your office of any possible or potential CJIS misuse. This has since been corrected, and all supervisory personnel in Internal Affairs are aware they must notify me when there is an allegation or a possible allegation of CJIS misuse, and then I notify you. They are also aware that I provide updates to your office every 30 days, along with the final outcome of the investigation and review by the chain of command. I am aware that Mr. Harnish from the CPOA has been in contact with your office, and he and I discussed the necessary steps moving forward and have agreed on best practices. As it relates to the complaint against Sergeant A, the investigation has been completed. However, the complaint is still now being reviewed by the chain of command. Once the review of the chain of command has been completed, it is possible there may be employee hearings if the allegations are found to be valid and discipline imposed. Once all of those steps of due process are completed, I will notify you of the final disposition and action if taken. Erica Wilson.
So,
I believe that those documents completely support my position about the handling of this case. We did not investigate it. I don't know Sergeant and I've never met him before. I have no agenda against him. I simply want the processes to be followed properly so that a true and fair investigation can take place. Thank you.
Mr. Harness, we don't have the full investigative file in front of us, and so in reading through it, the investigator refers to the CJIS/NCIC as if they're the same thing, which they're not. One is essentially owned by the state and another by the feds. So we don't have the CAD here to show exactly which way it was run. So was it NCIC run, or was it just the plate and there was no further investigation?
That is yet to be determined by the Department of Public Safety.
Okay, so we don't have the audit of NCIC to see if he ran it or not?
I don't have the file. I don't have the file either.
Why do they say MDC/NCIC if they're not the same thing? Why do they say it like that?
My understanding is that they can be run at the same time.
So when I asked you if the NCIC, do we have confirmation, in our committee meeting I asked, do we have confirmation that an NCIC thing was run? You said yes. Is that accurate, or is it just we're not sure yet? I mean, I understand what you're saying. It wasn't ours to begin with. The possibility of a criminal act, which would be to run it for no lawful purpose, was there. So you sent it, as the rules require, to Internal Affairs for them to run it. They come back and say that it's all good. But we still don't have an answer to the question about whether or not the NCIC was run. And your position is that the question of whether that was done should be answered by DPS, and therefore it should be referred to DPS. Is that correct? Do I have that right?
Chair Moore, Board Member Fine, that's correct.
Okay, so we're not making a statement by our letter that says the officer did anything wrong. We're saying the process doesn't appear to have been followed, and if it was not followed, the DPS can say it was kosher or it wasn't kosher, right?
Chair Moore, Board Member Fine, that's correct.
Okay, so we're not making a statement about the officer and his activities.
Chair Moore, Board Member Fine, that's correct.
We're commenting on process.
We're simply ensuring that the process is followed properly.
I got you. So, and when do we expect to hear from DPS? I understand it's gone to them.
Chair Moore, Board Member Fine, the entire file has gone to them now. There's been a follow-up. The final investigation has gone to them, and I believe that went to them a week ago Monday, along with the September 20th letter from Ms. Ray.
So there's two SOPs here, and these are not your findings. So this is a very unusual case to begin with. Normally, your staff does the investigation, it comes to us, and we either approve, modify, or amend your findings. In this case, they're not your findings, there's the chief's findings and his staff. So it's kind of a conundrum in a way. There's two SOPs here to deal with. One of them is the one having to do with officers being unable to speak about the department in a way that might bring the department into disrepute. This is an SOP I've laughed at for years because there's no way it would ever survive a challenge for constitutionality. Officers can say whatever they want. And, you know, you can discipline them for being unprofessional in some other way, but you can't tell them that they can't sit there and gripe about the department. And frankly, if that was the case, you'd be writing up every officer like every meal. I mean, what else?
To
do
say
you talk
nothing
about?
of every employee
To
in
gripe
every
about the chief,
workplace,
right?
everywhere.
Right, so I'm not even sure if that SOP comes before us out of your office, I can tell you I would be unhappy to see it. How's that? And as to the second one, if he didn't run NCIC, I don't think we can implicate that SOP. So I think that question has to be answered before we can even have an opinion.
So what I understand though is that the internal affairs review said he did run it.
I'm
But,
not sure I read that though, because they say,
well, I think they said he did run it, but he didn't really do anything with it. I think what Ed's saying is, if he ran it, it's not kosher. And DPS, it may not be kosher, and DPS is the one who decides whether it's kosher or not. And that's what I understand happened here. Is that correct?
Chair Moore, Board Member Fine, that's correct. I made no judgment as to whether or not it was proper. We had a complaint that was alleging that it was not proper from a citizen.
The complaint said they ran NCIC on me.
The complaint thought that personal information was gained by running the license plate.
But if what Mr. Willoughby said to us is true, running the license plate is not a problem. Running the NCIC is a problem.
If that's what only occurred. That's why.
Okay, there's a lot of distinctions to be made here. And it seems to me that we should, process-wise, my biggest concern is I specifically asked that question in the committee and was told it was, that we had confirmation that NCIC was run. What I'm hearing now is that we don't have confirmation. We're waiting to hear from DPS that there is or is not a violation. Is that correct?
Chair Moore, Board Member Fine, based upon the information that I had at the time, I was told that it was. But
Since
that's
then,
not, but that wasn't for us to determine. So we were to investigate whether or not it happened.
okay. All right, and we are not the ones to investigate, because if it had happened, if we had the reason why that's a problem is to run NCIC for no legal purpose is a crime. And that's why you would have to send it to Internal Affairs.
That is correct.
So it wouldn't be our case anyway. And your issue is process. Was the process followed? Is calling and talking to an attorney about whether hypothetically this was wrong or not is not doing what the policy says, which is DPS gets to decide.
well, we have a letter here from the NCIC officer of communications saying that part of the process wasn't followed because IA wasn't familiar with it and that's been fixed. So let me ask you this, Mr. Rouse, what are you asking this board to vote on exactly? Because we don't have findings from you
It's not a
to
vote, it's just a discussion.
affirm or not.
Chair Moore, I'm not asking the board to vote on anything. I'm simply bringing the information to you for the command staff's review and their non-concurrence with memo that this board, through me, sent dated September 8th, where Commander Sullivan makes it very clear that he believes he has the ability to do the criminal investigation and make those determinations. And my position would be that that's still contrary to paragraph 188 of the settlement agreement. Beyond that, it's clear that the proper steps weren't followed in this case for this type of a complaint. And I'm bringing the information to you as the board.
So it's all process. We're just
Yeah, this is just a
discussing process.
discussion, it's not a vote.
And I agree with that.
Mr. Baker.
Chair, more members of the board, the one thing I thought might be helpful, both for you all, but also for people who have been following along with this, is just briefly to talk about what paragraph 188 says, because that seems to be the fork in the road that started this.
Sure.
And paragraph 188 says, If at any time during this conduct complaint intake or investigation, the investigator determines that there may have been criminal conduct by any APD personnel, the investigator shall immediately notify the Internal Affairs Bureau commanding officer. If the complaint is being investigated by the Civilian Police Oversight Agency, the investigator shall transfer the administrative investigation to the Internal Affairs Bureau. The Internal Affairs Bureau commanding officer shall immediately notify the chief. The chief shall consult with the relevant prosecuting agency or federal law enforcement agency regarding the initiation of a criminal investigation. Where an allegation is investigated criminally, the Internal Affairs Bureau shall continue the administrative investigation of the allegation. Consistent with paragraph 186, the Internal Affairs Bureau may delay or decline to conduct an interview of the subject, personnel, or other witnesses until completion of the criminal investigation unless, after consultation with the prosecuting agency and the chief, the Internal Affairs Bureau deems such interviews appropriate. So in terms of the initial fork in the road, in terms of what determination is required at the agency level before something is sent to IA, the operative standard is that there may have been criminal conduct by any APD personnel, at which point the agency shall transfer to Internal Affairs.
It's possible, it's not found, it's not a finding, it's a possibility.
So at that stage, the agency isn't called on to determine whether there was or wasn't. It's if there may have been, and this has been a subject of a fair amount of discussion as we've been implementing the settlement agreement from the beginning, because the goal has been that where the concern expressed by the department and through representatives of the officers has been that they don't want the agency wading into the middle of what ultimately may be a criminal prosecution.
Right.
And we've agreed that that makes sense, and so we've articulated this and captured it in the ordinance as well. So that's the fork in the road. And then what Director Harness was summarizing then was the steps that followed from there, resulting in a finding by the chief. So the disciplinary process on this is done. If it finds its way back to the agency in some form or another, it's going to be somewhere
Because
down the road.
DPS found something.
At which
Or
point, it may, whether it would find its way back here, I don't know. I don't think that that's at all clear right now. But I'm only weighing in to provide context because there's been a lot of discussion of 188 this, 188 that. And I thought it would be helpful to just flag exactly what it says and requires.
That's helpful, thanks.
Well, it sounds, I'm sorry.
Hold on. Dr. Ori Martinez has been trying to talk for like
I'm
5
sorry.
minutes, so let's you go first.
Because I didn't see the original, what happened, and I'm trying to get this straight in my mind. I'm assuming that this, you were saying, is the process because there's an allegation that the officer did something illegal, but when I also remember somewhere, either hearing or reading, that the officer felt there was behavior by the other person that made him question what was going on to run the license plate. And I guess in my mind, I would think that because of the behavior, then that would also make sense that the officer would run NCIS, and that to me would not be NCIC. I'm sorry, too much. That the officer is within his rights, unless it, I don't know. I'm almost sounding like it's almost sounding like a witch hunt. I don't know. Am I wrong about that?
Chair Moore, Board Member Ori Martinez, the officer may well have been within his right to do what he did, but the determination for that is to be done by the New Mexico Department of Public Safety. There are certainly two sides to the story, and certainly Sergeant Anaya's recitation of his perceptions of what happened versus the statement that the complaint gave are divergent, and that's why there's investigations. And the investigation is to be done, and the review is to be done by the New Mexico Department of Public Safety in this instance, and that's the only point. It's not for us to make that determination.
And you have not made that determination.
No, ma'am.
Mr. Trevor? Yeah. I'm sorry, Mr. Waits, you had some?
No.
You have a question? Okay. Mr. Hemming?
I'm a little confused in regards to why we're hearing all this now. And it's part of the process, or are we going to make a determination for the sergeant? It seems to me that this has already been done and by the chief or assistant chief. So what is it that you all are asking of the board to do? I'm a little confused.
We wanted exposure to the full landscape of what's been presented to you. I mean, I've already heard distortions of the record by Mr. Harness tonight. You know, Mr. Tyler's complaint is 99% about an allegation of officers talking in a derogatory manner while he's at the teriyaki chicken bowl. The last sentence on page 1 of his complaint is, "With my education and training, I have no doubt that they were going to check my information to find out who I was." I mean, pure speculation. I mean, he doesn't allege that they unlawfully or without any reason searched him. It was just pure speculation. What does he do? He goes to his wife, who's the major at the academy. She orders an audit run of the search that Officer Anaya did. So by her actions of accessing the database, she identifies who did the search of his plate and then provides that information to her husband, who then subsequently files a complaint. Notwithstanding the fact that Mr. Harness and Investigator O'Neill were witnesses to Major Tyler's statements at the academy following what happened at lunch. So Mr. Harness shouldn't have any involvement in this matter whatsoever, since he was a witness to aspects of the incident. And you were asked numerous times about that, and you refused to answer.
Mr. Grover, please address the board.
Recuse yourself from it.
Mr. Grover, address the board, please.
Yes, thank you, sorry. And that's a fundamental issue. So to me, and why we're here, is that this is a challenge. What's been presented to the board is a challenge to the very integrity of this board and of the CPOA. Okay, and we're not going to let it slide. That's our concern, and that's what we want you guys to be aware of. You know, an officer sitting at a restaurant and sees an attractive woman come in and sees her go out and then runs her plate for the sole purpose of finding out who she is to get her information. Obviously, we're in a very bad place. Okay, we're talking misconduct, at least, right? That's stuff where we talk about, you know, possible prosecution. None of those elements are here. And it's based off a complaint that the officers are speaking poorly about the department. And then all of a sudden it becomes possible criminal violation because my office confronts Mr. Harness as for what are the allegations against my client. Of course I knew he was bootstrapping this investigation into something about NCIC. But it's awfully convenient that at the time that that issue is pressed, that's when it became, oh wait, it seems like your client committed possible crime, so pursuant to this order of the CASA, it's going to IA. It's important to us that the full facts are presented to you, not a thin slice. If there are pimples on it, there are pimples on it, so be it. But we want the full facts brought to your attention. And it's important to us because we want the board to succeed. But that means that sometimes everything comes out. And unfortunately, that's our concern, is that not everything is coming out.
Which is why we wanted you here tonight.
And I appreciate it. I appreciate it very much.
Okay, are there any other questions of Mr. Grover or Mr. Harness? Otherwise, I think we're moving on because we're not actually being asked to decide anything here. Okay? Anyone have anything else on this? All right, thank you.
Thank you.
Sergeant and Mr. Grover for being here.
Thank you, Chairman. Personally.
Chair Moore, fellow board members, let's just talk about NCIC one more time. As a result of this 88-16, I had contact with Erica Wright from the Communications Division, and I've also had contact with Amanda Lopez from the Department of New Mexico Public Safety. And henceforth, any investigation that comes in with any allegations related to CGIS or NCIC, our agency will do the initial investigation and we will report our findings, or we will report our investigation directly to NCIC, and we will inform APD so that they can live up to their duties under their charter. The New Mexico Department of Public Safety assured me that they would need about a 2-week turnaround time, so that would be enough time for them to do their evaluation. And if they determine that there is no criminality, then we can go ahead and do the investigation. And if it is to be criminal, then we would simply follow paragraph 188 and return it over to Internal Affairs and have them take over.
Okay,
So that's going to be the practice moving forward.
I think that's going to be a good practice, and I think now that everyone's kind of figured out where we are on this, and Internal Affairs has their policy, I think that will work going forward. Potentially, anytime somebody runs anyone at NCIC, it could involve criminality, but we don't want to stop every single investigation to look at that, right? So I think that's good.
I think it's worthy of note too that in the Journal recently there was an article that was from Associated Press about the abuse of NCIC across the country by police officers. And so this is a problem that's significant and one that I think every community needs to pay attention to. It would be a very easy trap to fall into, to use that as a personal database to check out everything under the sun, everybody you have an association with in your life. It's illegal for a reason. And so I think it's important that we pay attention to this in terms of a pattern, whether it's this case or any other case. And it behooves not only this board, but APD to make sure that we pay very close attention to any potential abuse that might be happening. And I assume that Internal Affairs feels that way as well.
So included in our packet, if I can find it, was here we are, Department of Special Order 15-21. It went out in March of 2015 and talks about appropriate use of NCIC, and it gives examples of misuse. For example, a officer running inquiries on the estranged wife of a friend and providing that information to the friend, knowing there's a restraining order. That officer was indicted on 12 felony counts of computer tampering and was ultimately sentenced to 3 years probation on the loss of his law enforcement career. Another example, a detective was sentenced to 18 months imprisonment for the unlawful access of the law enforcement database, specifically license plate, driver's information, and warrant information. He ran someone believed to be having an affair with his spouse. So it might be a good idea for APD to send this out again, even though it's just been within the last year, since it's been in the headlines and everything else, because it's a very well-written special order with excellent examples of what's bad.